Hello, this is Miranda Short and Lonnie Bryant, and we are giving a presentation on music piracy for Business Law 2150. Hope you guys enjoy. What is music piracy? The United States Copyright Office defines music piracy as the copying and/or distribution of copies for music for which the owner did not give consent. Common examples include downloading and distributing copyrighted music through peer-to-peer file sharing websites, or burning CDs for you and your friends. Prevalence. According to the Recording Industry Association of America, close to $2.5 billion are lost in the music industry every year due to music piracy. Many online sites provide access to the downloading and distributing of illegal music, which ultimately grants listeners music for free. Who music theft hurts. Music piracy has the potential to hurt songwriters, recording artists, audio engineers and computer technicians, talent scouts and marketing specialists, and producers and publishers. As of today, music piracy causes approximately $12.5 billion in losses in the U.S. economy, nearly 70,000 lost jobs, and $2 billion in lost wages to American workers. Law of the land. Directly pulled from Title 17 of the United States Constitution, federal law provides severe civil and criminal penalties for the unauthorized reproduction, distribution, rental, or digital transmission of copyrighted sound recordings. Digital copyright laws are currently being reevaluated in Capitol Hill to improve the issues and legalities concerning music piracy. Trending legal issues. It is no secret that millions of people illegally download and share music every day. According to a recent poll by the RIAA, nearly 70% of 18 to 29-year-olds believe that file sharing is in fact acceptable. This high percentage of young people indicates that music piracy will only continue to rise and negatively affect the music industry sales over time. Congress is concerned that the Online Stop Piracy Act and other trending proposals may lead to a decreased global internet freedom, which could then potentially lead to other legal issues. There is a lot of gray area concerning copyright law, which makes it increasingly difficult to prosecute offenders. Our main focus. We decided to focus on websites who provide access for peer-to-peer file sharing. These websites are the main source of music piracy. U.S. law has been working to combat this issue through the proposal of new anti-piracy acts and persecuting those liable. These following slides concern the case of Napster versus A&M Records. Analyzing this case supports our main focus of issue with peer-to-peer file sharing websites.
Napster was a peer-to-peer file sharing network where the public had access to shared music through MP3s. The defendants were major record companies who felt this technology would negatively impact their record sales. These reproductions and distributions were in fact copyright violations, and the defendant quickly filed suit against Napster. The U.S. District Court of Northern California found that Napster had indeed contributed to infringement of copyright owned by the defendant and issued an injunction from which Napster appealed. Music Records sued Napster for direct, contributory, and vicarious infringement of copyright in efforts to protect their work. Napster failed to claim fair use because their work was not used for the purposes of criticism, comment, news reporting, teaching, scholarship, or research. To determine whether the defense was met, the statute directed the court to consider these four factors. The first factor is the purpose and character of the use, whether it was used for commercial or educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the work as a whole. And 4. The effect of the use upon the potential market for the value of the copyrighted work. When analyzing this case, according to Michael W. Carroll, both courts' analysis of fair use could have been more specific. Carroll stated, even with the asserted fair uses, both courts should have analyzed whether the uses were fair on their own terms, and then analyzed the proportion of Napster use that could be characterized as sampling or space shifting. Carroll believes if both courts' description of fair use had been consistent with each other, then the ruling may have better expressed the balance between rights of copyright owners and users. Cornell law found the previous four factors to be met through Napster permitted the activity, repeated and exploitive copying, the songs were considered close to the core in relation to the creative works, and the entire songs were downloaded. Also, the effects of downloading these songs were found to harm possible album sales. As for contributory infringement, Napster was aware of the widespread infringement taking place and failed to prevent it. According to Carroll, it is possible to have a system which allows infringing activity without being liable. However, as soon as one begins using this system, they must exercise full supervisory authority or they will be held liable. Carroll claims that the District Court and the Ninth Circuit failed to hold Napster to the same standards for vicarious liability, and for this reason, Napster appealed. As for the ruling, a federal appeals court affirmed a lower court ruling that Napster encouraged and allowed the wholesale infringement of copyrights. Napster settled with the plaintiff for $26 million and filed for bankruptcy 1 year later. We feel as though Napster deserved the persecution for copyright infringement. Napster provided the source for infringement to thrive through peer-to-peer file sharing of copyrighted work. Artists and music companies within the industry deserved the relief that they received, as their creative work was mass-produced and distributed without compensation. As previously stated, Carroll found that the secondary liability and fair use definitions failed to line up for each court. We agree that if the district court would have been more detailed on its standards, then perhaps Napster would have not felt the need to appeal the injunction. Although it is unrealistic to persecute every infringer, music piracy is a criminal offense and should never be taken lightly. If better defined, copyright laws will potentially have stronger defense. It will also aid artists in developing stronger cases when pursuing justice. The Napster vs. A&M Records case served as the first intellectual property case to address the application of copyright laws to peer-to-peer file sharing. The success of this case has led to a dramatic decrease in peer-to-peer file sharing websites. Unsurprisingly, many of your average citizens are at fault for this criminal offense. However, viewing music piracy through an artist's lens will give one greater insight onto the negative impact it has on the music industry. Once again, this is Miranda Short and Lonnie Bryant, and we are signing out. Thank you so much for listening, and we hope you enjoyed.